Notwithstanding all that we've said until now, balancing actually plays a very important role in assessing personal jurisdiction. But the important thing to remember is that you do the balancing test last, not first. That is, once you've determined that the defendant has minimum contacts and has personally availed himself of the forum state, then you ask whether jurisdiction ought to exist as a matter of fairness. In other words, fairness balancing, which we're going to describe in a minute, is a shield, not a sword. You can use it to defeat jurisdiction. You cannot use it to create jurisdiction. The Burger King court announced 5 factors for courts to use to balance. Number 1, the burden on the defendant. How difficult is it for the defendant to defend his suit in this particular state? For example, Asahi. The court there said it was a significant burden to require a foreign manufacturer to defend a case in the United States despite having no presence in the United States. Number 2, the forum state's interest in adjudicating the dispute in that state. All states have an interest in adjudicating disputes regarding their citizens, but they also have an interest in cooperating with other states. When you want to determine whether a state has a real interest, look to state law to figure out what the state public policy is. A state that has a strong public policy for or against gay marriage, for example, will have an interest in keeping the constitutional litigation on that issue within its borders. Number 3, the plaintiff's interests in that state for convenience and for obtaining effective relief. How important is it for the defendant to be where he brought the suit? Now, there will almost always be an argument that it is important. Obviously, the plaintiff chose this forum, he chose it for a reason. So obviously the plaintiff wants to be there, and you're probably going to be able to make an argument that there is some significant interest on behalf of the plaintiff for remaining there. But note that the plaintiff's interests are almost never enough to independently justify personal jurisdiction. You're almost always going to have to find something else to justify personal jurisdiction once you get to this balancing test. Number 4, judicial efficiency. This is a big issue when jurisdiction exists with regard to some claims in a lawsuit and not others. And as a result, the suit will have to be split among 2 forums. That creates duplicity and judicial waste, which we like to avoid. For example, if John punches Joe in the face in Wisconsin while on vacation over a contract dispute regarding a business relationship that they have in Michigan, jurisdiction might not exist in Wisconsin over the assault and battery case, even though it happened there. Why? Because Wisconsin will likely not have jurisdiction over the contract dispute, which after all has nothing to do with Wisconsin. If Wisconsin took jurisdiction over the assault and battery claims, but not the contract claims, that would necessitate 2 proceedings in 2 separate courts. Now, to the extent that the 2 claims are related, which is probably a very big assumption on these facts, and in fact they're probably not related, but let's pretend that they are for the sake of discussion, it would be better to litigate those 2 claims in the same forum rather than in 2 separate forums. And so the big issue when you're assessing this is going to be whether the 2 claims are in fact related, whether they have the same facts and relate to the same transaction, such that it would be inefficient to split them into 2 trials, 2 separate fora. Number 5, the quote, and I'm quoting directly out of the Burger King court now, the quote, shared interest of the several states in furthering fundamental substantive policies. I'll read that again. The shared interest of the several states in furthering fundamental substantive policies. For example, Asahi said that all states share an interest in not excessively burdening a foreign corporation. That's a shared interest of the several states. It's thus a fundamental substantive policy of the several states, and therefore something to take into account when assessing jurisdiction. If there's a shared interest in not asserting jurisdiction over a foreign corporation, that's going to very significantly counsel against jurisdiction in Asahi, as it in fact did. Other courts have added a 6th factor. I told you there were 5. Burger King set forth 5, other courts add a 6th. The existence of an alternative forum. If, as a practical matter, denial of jurisdiction in this case will mean that the claim will not be adjudicated anywhere, not in the US, not on foreign soil, nowhere, the court will be far more likely to find jurisdiction, if and only if minimum contacts and personal availment exist, of course.